You usually expect like a certain atmosphere when a major business deal closes, you know?
Yeah, there's always this expectation of excitement.
Right, it's all handshakes, maybe some champagne being poured, and you have these grand visionary speeches from founders or CEOs about synergy and disrupting the market.
It is entirely celebratory. I mean, the entire focus of that moment is completely on the upside.
Exactly. Everyone signs the paper, the photographer snaps a picture for the press release, and the whole room just points to the horizon and says, like, there is the future.
Right.
And it feels clean, it feels optimistic. But then if you actually step out of that boardroom and look at the paperwork itself, the contract that everyone just smiled and signed,
Yeah.
suddenly that champagne glass is like half empty.
Oh, absolutely.
We're looking at a landscape that is honestly incredibly paranoid. I mean, most people look at a commercial contract and just see this boring, impenetrable pile of legalese.
Yeah, it's dense. It's unreadable to most people.
It feels completely disconnected from that happy handshake.
It really does have a reputation as the ultimate buzzkill for business operators.
Totally.
People who, build things or sell things, they tend to view the contract as this annoying hurdle, like something they just have to jump over before they can get back to the actual work.
Right, the real work.
Exactly.
Yeah.
But looking at it that way is just a fundamental misunderstanding of what the document actually is and what it does.
So I was going through some materials recently, specifically this masterclass on drafting risk allocation clauses.
Oh, yeah.
And it completely changed my perspective on this. Because when you actually learn how to read these things, you realize they aren't just administrative forms.
Not at all.
They are these intricate, highly engineered blueprints for disaster management. So our mission for this deep dive is to unpack this. We're going to look at Masterclass 3, drafting risk allocation clauses.
Like, it's a great topic.
Yeah, we're going to see how you translate a real-world business deal into specific legal architecture, specifically focusing on how risk is assigned for claims, delays, variations, and liability.
Right.
The goal for you, the listener, is to stop reading contracts like a casual consumer and start reading them the way a deal architect does.
And to really get into that mindset, the mindset of a deal architect, we have to completely reframe our basic understanding of what a contract is.
Okay, how so?
Well, when most people think of the law, they picture litigation.
Yeah, like a courtroom.
Exactly. A courtroom, a judge, a jury, and two sides fighting over something that has already happened. Litigation is inherently backward-looking.
It's all in the past.
Right. It looks at a car crash or a fired employee or, a broken promise. And it tries to retroactively assign blame and calculate damages for that past event.
So it's basically a forensic exercise, like you're digging through the rubble to see whose fault the fire was.
That's exactly it.
Yeah.
But a commercial contract is entirely different. A contract is essentially a piece of private law.
Private law, I like that.
Yeah, when two companies sign an agreement, they are literally legislating the rules that will govern their specific private universe. It's a planning document. So transactional drafting looks forward to govern a future relationship. It anticipates tomorrow. It dictates how both sides will behave when certain inevitable or, even highly unlikely things occur.
The analogy that came to mind while I was reading through this masterclass is that drafting a contract is like building a highly customized insurance policy for one very specific relationship.
That's a really good way to look at it.
But in this insurance policy, the currency you're trading isn't money. The currency is exact words.
Yes, absolutely.
Like the placement of a comma, or the choice between the word if and the phrase provided that, which we'll get into later.
Oh, we definitely will.
Those tiny linguistic choices are the actual levers that shift millions of dollars at risk from one side of the table to the other.
Because every single word establishes a standard of liability.
Right.
Every adjective and every adverb is like a tiny weight placed on one side of the scale or the other.
Right.
And before we get into the heavy machinery of specific clauses, like what happens when a massive construction project is delayed, or who pays when a catastrophic lawsuit hits, we first have to understand the foundational philosophy of a deal lawyer.
The mindset.
Exactly. How do they view risk, and how do they translate real-world scenarios into that legal architecture?
And the materials call this the translation skill, which I found fascinating because it's so radically different from what they teach you in like a standard trial advocacy class in law school.
It really is. It's the bedrock of transactional law. Let's compare it directly to the litigator's skill set.
Okay, let's do it.
So a litigator takes an existing set of facts, Let's say a driver was going 80 miles per hour in a residential zone and hit a pedestrian.
Awful, but okay.
Right.
Yeah.
The litigator takes those static, unchangeable facts and applies the established law of negligence to them in order to persuade a judge or a jury.
They can't change what happened.
Exactly. The facts are locked in the past, the litigator is stuck with the hand they were dealt, and their only tool is persuasion.
They can't change the speed of the car. They just have to argue about what that speed means under the law.
But a drafter, a deal lawyer, operates in reverse. They start with a business deal.
Right.
Let's say a client wants to buy a manufacturing company. Those business goals, that desire to acquire assets and market share, those are the deal lawyer's facts.
Okay, so the future goal is the fact.
Yes. The deal lawyer then has to find the exact contract concepts, things called representations, warranties, covenants, and conditions that best reflect and protect that business deal.
They're building the box.
Right. They literally translate the messy business reality into a rigid legal structure. And their goal isn't to win an argument in court. Their goal is to prevent the argument from ever happening in the first place.
Which sounds impossible, frankly. I mean, when you have two massive corporations with competing financial interests, how do you draft a document that prevents them from arguing when things inevitably go sideways?
You do it through obsessive, methodical risk allocation. The philosophy is actually quite structured. Every commercial contract fundamentally exists to answer 4 vital questions about risk.
Okay, what are the 4 questions?
Number 1, who carries the risk? Number 2, when does the risk transfer from one party to the other?
Got it.
Number 3, what evidence is required to prove that the risk has actually materialized? And number 4, what remedy follows if things go wrong?
So who carries it? When does it move? How do we prove it? And who pays?
Exactly.
I want to look at a concrete example from the text because I think it illustrates this perfectly. It's about a very simple statement. There is no litigation.
Ah, yes. The classic.
Right, because if I'm buying your company, that's a pretty standard thing I want to know. Are you guys currently being sued? Are there any hidden landmines that are going to explode the second I take over?
It is known in the industry as the no litigation representation. And a representation is just a statement of past or present fact. So as the buyer, you want the seller to promise you on paper that there are no hidden lawsuits that are about to bankrupt the business you just purchased.
So as the buyer, I slide the contract across the table and it simply says, there is no litigation, period.
Right.
But as the seller, your lawyer is going to look at that sentence and see a massive glowing red threat.
Oh, absolutely. Red sirens everywhere.
The Masterclass breaks down 3 versions of how this plays out, and it's basically a masterclass in shifting risk. So version 1 is the flat rep. The contract just says verbatim, there is no litigation. What happens if the seller actually signs that?
Well, they are taking on an immense, almost reckless amount of risk.
Yeah.
A flat representation creates a standard of strict liability.
Strict liability.
Yeah. Imagine the seller is a massive corporation with like 50 offices nationwide. They sign that flat rep on a Tuesday.
Okay.
It turns out that on Monday afternoon, a disgruntled former employee in a satellite office 3 states away filed a small claims lawsuit for unpaid overtime.
Oh.
Right. The CEO didn't know about it. The general counsel didn't know about it. But the seller has just breached the contract.
Because the representation was absolute.
Exactly. It was absolute and it was technically false. So the buyer now has grounds to sue for breach of contract or potentially walk away from the deal entirely over a minor issue no one even knew existed.
Just because the words didn't leave any room for reality, the risk of the unknown lawsuit was placed 100% on the seller's shoulders.
Right, which is why a good seller's lawyer will never accept it.
So the seller's lawyer pushes back, and this brings us to version 2, the knowledge qualified rep.
Yes.
The seller says, look, I'm not signing a flat rep. I have 10,000 employees. I can't know everything, but I will sign this. To the seller's knowledge, there is no litigation. How does that change the scale?
The risk just shifted dramatically back to the buyer. Just by adding those 4 words to the seller's knowledge, the seller has completely changed the standard of liability.
4 words.
4 words. Because now, if that hidden lawsuit pops up after the deal closes, the buyer cannot just point to the lawsuit and claim a breach. The buyer has to prove that the seller actually knew about the lawsuit before closing and intentionally lied about it.
And proving what was inside someone's head is notoriously difficult, right?
It is one of the hardest things to do in laws. Unless you find a smoking gun email where the CEO says, hide this lawsuit from the buyer, you're going to have a very hard time winning that case.
Wow.
So by adding a knowledge qualifier, the buyer is now forced to carry the risk of any unknown lawsuits.
But if I'm the buyer, I mean, I don't really care what the seller knew or didn't know. My bank account doesn't care if the seller was ignorant or malicious.
Exactly, a loss is a loss.
Right. If I buy a company and immediately get hit with a $10 million patent infringement suit, I am still out $10 million. So I am not going to accept a knowledge-qualified rep that leaves me holding the bag.
Which is why you need a compromise.
Right. Which brings us to version 3, the materiality qualified rep.
This is where deals usually land. The buyer says, look, I am not trying to trap you over a $1,000 slip-and-fall case. I don't care about the minor stuff.
Yeah.
But I do care about lawsuits that threaten the core business.
Right.
So they draft it like this. There is no litigation that would have a material adverse effect on the company.
Ah, material adverse effect, the famous MAE clause.
Right. It's the ultimate compromise. It focuses the risk allocation only on the deal-breaking issues.
It filters out the noise.
Exactly. The seller is protected from being sued over tiny, immaterial, unknown lawsuits. And the buyer is protected from the catastrophic, company-ending ones, regardless of whether the seller knew about them.
So the risk has been allocated based on the financial severity of the threat, rather than just knowledge or strict liability.
Yes.
You know, this back and forth raises a really common frustration I hear from business folks who are just trying to get a deal closed.
Let me guess. Lawyers are deal killers.
Yes. If a lawyer spends all their time pointing out remote, terrifying risks, and then dragging out negotiations to fight over microscopic word changes like knowledge versus materiality, don't they just become a giant deal killer?
Right.
Doesn't this endless paranoia just ruin the goodwill and the momentum between two parties who actually want to work together?
It is a very common complaint.
Yeah.
And frankly, if the lawyer is inexperienced or if they're just trying to prove how smart they are, it's a valid complaint.
Really?
Yeah, because spotting a risk is easy. Any first-year law student can look at a contract, spot a potential disaster, and say, oh, don't sign this. It's too dangerous.
Right.
But that is not what a master drafter does.
Spotting the risk is only step 1?
Exactly. A great deal lawyer does 3 specific things after spotting the risk. First, they assess the actual probability of the risk occurring.
Like, is this actually going to happen?
Right. Is this a once-in-a-century flood scenario, or is this a highly likely supply chain disruption?
Okay.
Second, they calculate the financial consequences.
Just dollar amount.
Yeah. If this specific bad thing happens, are we talking about a $5,000 inconvenience or a $5 million existential threat? And third, they assess their own client's risk aversion profile.
Which varies wildly depending on who you represent, I imagine?
Oh, massively. A venture capital firm backing a tech startup is highly tolerant of risk. They expect things to break.
Move fast and break things.
Exactly. But a conservative regional bank lending money for a factory, they are highly intolerant of risk. They want absolute certainty.
Right.
So once a lawyer understands the probability, the cost, and the client's tolerance, the goal is not to kill the deal. The goal is to mitigate the risk creatively so the deal can survive.
The Masterclass materials give a really great example of this creative mitigation regarding how a transaction is structured.
The environmental one.
Yes. Let's say a company is buying a competitor, and during the due diligence phase, they discover a massive toxic environmental risk at one of the competitor's old factories.
A literal toxic asset.
Right. A bad lawyer looks at that and says, environmental cleanup costs are a black hole. The risk is too high. Kill the deal.
But the business still wants the competitor's technology in their customer list.
Exactly.
So a great lawyer looks at that same toxic risk and says, let's change the entire legal structure of the transaction.
How so?
Instead of doing a stock acquisition, where we buy the corporate entity and inherit all of its hidden baggage and liabilities, let's do an asset acquisition.
Meaning we don't buy the company, we just buy its stuff.
Precisely. You draft the agreement to state that you are only purchasing specific enumerated assets. The patents, the software, the machinery, the customer database.
Right.
And you explicitly state that you are not assuming the liabilities associated with that old factory.
That's brilliant.
The seller keeps the corporate shell and the toxic factory. The buyer gets the valuable assets they wanted. The deal still happens, the business goals are met, but the catastrophic risk has been structurally isolated and left behind.
See, that is the difference between a deal killer and a deal architect. It's not just playing with vocabulary, it's architecting the transaction to sidestep the landmine entirely.
Exactly.
Okay, so we've established the foundational philosophy. Every word shifts risk, and the goal is to allocate that risk based on probability and severity.
Yes.
Now, let's apply this to what is arguably the single most common bleeding financial wound in any commercial project: time risk.
Time is the great enemy of the commercial contract,
Because time is money.
especially in construction, manufacturing, or, software development.
Right. If time is money, a delay is just a massive pile of money being set on there every single day.
Yep.
The source material provides a really stark contrast between a weak delay clause and a strong delay clause.
This is a great section.
Yeah, imagine a real estate developer hiring a general contractor to build a $100 million high-rise. The developer is in a rush. They want to break ground, so they tell their lawyer, look, just put in the contract that the contractor must complete the project on time and maintain high quality. Keep it simple so we can get started.
Let me just say, keep it simple. In a $100 million construction contract is essentially a suicide note for the developer's margins.
Let's look at what the text calls the weak clause. It reads simply, contractor shall complete the project within the period.
It's terrifying.
But why is that seemingly straightforward sentence so dangerous? To a layperson, it sounds perfectly clear.
It's disastrous because it lacks mechanism, it lacks definition, and it lacks consequence.
Okay, break that down.
Think about the word complete. What does complete the project actually mean on a high-rise?
The building is standing.
But does it mean the roof is sealed? Does it mean the fire marshal has signed the certificate of occupancy? Does it mean the landscaping is done and the carpets are vacuumed?
Oh, I see.
If you don't define the exact criteria for completion, the contractor is going to stop work when they think they're done, the developer is going to withhold the final payment because the lobby isn't finished, and you are going straight to court.
And what about within the period? That sounds okay, right?
It is equally vague. What period? When did the clock actually start ticking?
Right.
Does the period pause for federal holidays? Does it pause if there's a hurricane? Does it pause if the city takes 3 months to approve a zoning variance?
A weak clause provides no answers.
Exactly. It's just a blank check for ambiguity, and ambiguity always leads to litigation.
Okay, so the Masterclass outlines the anatomy of a robust, strong delay clause. It argues that a delay clause isn't just a rule, it's a machine with moving parts that dictates exactly what happens when the timeline inevitably slips.
Yes, there are 7 specific components.
Let's walk through them because this really shows the mechanics of drafting. What's number 1?
Component number 1 is a precise commencement date. You cannot calculate a delay if you don't know exactly when the clock started.
Right, that makes sense.
And it usually shouldn't just be the date this contract is signed. It needs to be an undeniable, objective trigger. For example, commencement begins on the date the municipality issues the final foundation permit.
Because if the contract is signed in January, but the city drags its feet on the permit until March, the contractor shouldn't be penalized for those 2 months.
Exactly. You don't want to carry the risk for the city's delay.
Right. What's the second component?
Component number 2 is strict program obligations. You cannot just tell a contractor, see you in 2 years, and hope for the best.
Just hand them a check and walk away.
Right. The contract must require the contractor to submit a detailed baseline schedule and then submit updated progress reports every single month.
Oh, so it's an early warning system.
Precisely. If the concrete pouring is 3 weeks behind schedule in month 4, the developer knows about it in month 4, not in month 23 when it's way too late to fix.
It forces transparency. Okay, what is component number 3?
Predefined delay events. You have to explicitly list what types of delays actually excuse the contractor and grant them extra time.
Like a force majeure thing.
Exactly. This is where you define it. An earthquake. Yes, that excuses a delay. A nationwide steel shortage. Maybe, if it was negotiated.
What about if they just mess up?
Right, like the contractor's own crane breaking down because they didn't maintain it? Absolutely not. That is entirely on them. No extra time.
Okay, component 4 is notice requirements, which I know we're going to dive deeply into in a moment because the text says it's a massive trap. But briefly, what is it?
Simply put, if an excusable delay event happens, like the earthquake, the contractor must notify the developer within a very specific time frame.
They can't just spring it on them at the end.
Right. They can't wait 6 months and then say, oh, by the way, remember that earthquake? We need 3 more weeks.
Right. Component 5 is an assessment mechanism.
Yeah, because who actually decides if the delay was valid and how much time it cost?
I guess the developer?
No, they have a massive conflict of interest. They want it done fast.
Oh, right. Is it the contractor?
Obviously not. They want all the time in the world.
So who does it?
Usually you appoint an independent third party, like the lead architect or an independent certifier, to assess the claim objectively based on the contract rules.
Okay, that makes sense. Component 6 is extension entitlements, meaning exactly how much extra time is granted based on that assessment.
Yes.
And finally, component 7 is employer remedies.
Right. If the contractor is just plain late, no earthquake, no excuses, they just failed to finish the building on time, what happens?
Somebody has to pay.
You must spell out the financial penalty. This is usually liquidated damages, which we will cover later, where they pay a specific amount, like $10,000, for every single day they are late.
Okay, I want to zoom back in on component 4, the notice requirements. This is where the drafting language workshop aspect of the masterclass really shines.
Yes, the vocabulary matters so much here.
The materials highlight the absolute danger of using fuzzy, subjective words when drafting these mechanisms. And the biggest culprit in delay notices is the word promptly.
A terrible word for a contract.
As in, the contractor shall promptly notify the employer if a delay event occurs. Why is promptly such a toxic word for a deal lawyer?
Because promptly is an inherently subjective standard. It means different things to different people.
Give me a hypothetical.
Okay, let's play one out.
Yeah.
Imagine it's a Friday afternoon at 4 p.m. on the construction site. A main water pipe bursts. It is a massive crisis.
A total disaster.
Right. The site manager, the foreman, and the crew, they spend the entire night knee-deep in mud, frantically trying to shut off the water and secure the site.
Okay.
They finally get it stabilized at 6 p.m. on Saturday. The site manager goes home, collapses, sleeps through the weekend, comes back to the office on Monday morning, and sends an email to the developer notifying them of the delay.
Okay, so was that notice sent promptly?
That is the million-dollar question.
I mean, it seems like it to me he was dealing with a flood.
And the contractor's lawyer will absolutely argue that. They'll say, of course it was prompt. My client was managing an emergency, contained the crisis, and sent the notice on the very next business day. That is the definition of prompt.
Right.
But the developer's lawyer will argue, no, prompt means immediately. If you had called us at 4:05 p.m. on Friday, we could have dispatched our own emergency municipal water crew and saved $50,000 in water damage. Waiting until Monday was a breach of the notice requirement.
Oh, wow. And because you use the word promptly, the contract doesn't have an answer.
Exactly. So now you have to hire 2 teams of litigators, billing hundreds of dollars an hour, to argue over the philosophical definition of the word promptly.
In front of a judge who wasn't there, doesn't know anything about construction, and just wants to clear their docket.
You have completely failed the primary mission of the transactional drafter, which is to keep the parties out of court.
So how do you fix it?
The fix is remarkably simple, but it requires relentless discipline during the drafting phase. You have to eradicate subjective standards and replace them with objective, measurable clarity.
So no more promptly.
Right. Instead of promptly, you write, the contractor must notify the employer no later than 3 business days after the occurrence of the delay event.
It's binary.
Yes. You either sent it within 3 days or you didn't. There's nothing for a judge to interpret.
The analogy I kept thinking of while reading this section is setting your alarm clock for an early morning flight.
Oh, I like this.
Let's say you have a flight at 9 a.m. You do not set your alarm clock for morning-ish.
No, you don't.
You don't set it for promptly after sunrise or as soon as reasonably practicable after the roosters crow.
Because if you do that, you are guaranteeing that you will miss your flight.
Right. You set the alarm for exactly 6 a.m. Using words like promptly, reasonably, or substantially in a contract is literally setting an alarm for morning-ish.
It's so true.
It feels easier in the moment because you don't have to make a hard decision, but it guarantees a disaster later.
It is a phenomenal analogy, and it applies to every single clause in the contract. Don't say the contractor must use industry-standard quality materials.
Say they must use materials meeting ISO 9001 certification standards.
Exactly. Don't say a breach results in a significant penalty. Say it results in a $25,000 fee.
Specificity is the armor.
Yes, specificity is the armor that protects the risk allocation. If you leave a gap in the specificity, litigation will inevitably fill it.
All right, so we've secured the timeline. We have the 7 components of a strong delay clause. We know when they start, what excuses a delay, and exactly how many days they have to tell us about it.
We're covered on time.
But this brings us to another massive risk. What happens when the actual plan changes?
Ah, yes.
Because anyone who has ever done even a minor kitchen remodel, let alone built a skyscraper or deployed enterprise software, knows that the plan always changes.
Scope creep is inevitable. It always happens.
Delays are often caused not by bad weather or burst pipes, but by variations in the work itself. The developer decides they want an extra floor, or the software client decides they need a new feature halfway through the build.
Right.
So how do you draft a contract to manage a reality that hasn't happened yet?
You have to build in a mechanism for change management. A well-drafted contract must anticipate its own evolution.
Like it has to be flexible.
It has to contain the legal DNA for how it will be mutated safely. If you have a rigid, static contract and the scope of work changes, the contract simply breaks. You need a formal variation clause, also known as a change order clause.
The Masterclass details a 5-step mechanical process for a change order. Let's walk through it because it shows how tightly controlled this evolution needs to be.
It really is tight. First, you need a mechanism for an employer instruction.
Okay, what's that?
How does the employer legally instruct the contractor to change the work? It cannot just be a text message. It has to be a formal written notice detailing the requested change.
Got it. Step 2.
Second, the contractor proposal. The contractor receives the instruction and is required to come back with a detailed written proposal outlining how much the change will cost and how it will impact the schedule.
They can't just say, sure, we'll figure it out later. They have to price it up front.
Exactly. Third is the valuation mechanism. This is critical.
How so?
Well, if the employer says, add a new electrical outlet in every room, how do we price that fairly? Do we use the unit rates for electrical work that were already agreed upon in the original contract?
Or if it's totally new work, do we require the contractor to get 3 independent bids?
Right, to prove they aren't price gouging the employer. The contract has to dictate how the math is done.
Okay, step 4 is time impact. The change order must explicitly state how many extra days are added to the overall project schedule because of this specific variation.
Yes, very important.
And step 5, again, is notice requirements. Strict timelines on when these proposals must be submitted and approved so the project doesn't just stall out while they negotiate the cost of a single outlet.
You don't want the whole site shut down over an outlet.
To really highlight the drafting precision required here, the text uses a highly specific, almost microscopic example about bathroom tiles.
Oh, the provisos example.
Yeah, it's used to illustrate the concept of provisos and how changes are conditionally approved. This might sound like a grammar nerd's paradise, but the financial implications are huge.
It is the perfect example of how syntax dictates liability.
Let's lay it out.
Let's say the owner of a custom home being built decides halfway through that they hate the standard white ceramic bathroom tile in the master suite and they want imported Italian marble instead.
Naturally.
Right. The contract needs to allow the owner to make this change, but the contractor needs to be protected from suddenly having to pay for marble out of their own pocket.
Right. So here's the wrong way to draft it, according to the Masterclass. The owner may change the bathroom tile, provided that the new tile does not cost more than the original tile.
Yes.
What is the problem with provided that? People use that phrase in business communication all the time.
They do, and it is a symptom of sloppy, archaic drafting.
Really?
Yeah. Provided that is a dangerous phrase because historically, under the law, it creates an exception to a rule, not a clear condition. It creates massive ambiguity.
Give me an example.
Let's say the owner goes ahead and picks the expensive Italian marble anyway. Under the provided that language, did the owner just breach the contract by picking a more expensive tile?
I mean, I would think so.
But if so, what is the remedy? Does the contractor have to install the marble anyway and then sue the owner later for the difference in cost? Or does the contractor have the legal right to halt work and just refuse?
It's completely muddy. You don't know who has the power to do what. So what is the correct way to draft it?
The correct way replaces provided that with one tiny, incredibly powerful word. If.
Just if.
The contract should read. The owner may change the bathroom tile if the new tile does not cost more than the original tile.
It seems like such a minor change, just swapping a phrase for a 2-letter word.
But legally, it changes the entire structural architecture of the clause. Using if creates a clear, unmistakable condition to the owner's discretionary authority.
Okay.
The owner only has the power to change the tile. IF, the condition equal or lesser cost is met.
So if they pick the expensive marble,
The condition fails. And because the condition fails, their contractual authority to issue the change order simply vanishes. It doesn't exist.
Wow.
Therefore, the contractor can flat out refuse to install the marble, and the contractor is perfectly protected from being in breach of contract. It is a binary, airtight allocation of power and risk, entirely dependent on the word if.
I mean, I understand the legal beauty of that, but I have to push back here on behalf of the operations people.
Sure, go ahead.
The project managers, the people actually on the ground doing the work. isn't requiring a formal written change order complete with proposals, valuation mechanisms, time impact analysis, and perfect if-then grammar for every single tiny variation just paralyzing the actual work.
It sounds like it, yeah.
If the owner walks on site and says, "Hey, move that light switch 2 inches to the left," and the electrician says, "Sure, takes 5 minutes," do we really need to stop everything, call the lawyers, and draft a legal addendum? Doesn't that bureaucracy just kill the momentum of a project?
It is the ultimate tension between operations and legal, and happens on every single project.
I bet.
The operations team wants to be agile, the legal team wants to be secure. But the answer from the source material and from decades of case law is unequivocal. Yes, you absolutely must do the paperwork no matter how small the change, because of what is known as the cascade effect.
The cascade effect. Let's unpack that. How does moving a light switch 2 inches cause a cascade?
Well, moving a light switch seems trivial in isolation, but let's follow the cascade. The electrician agrees verbally to move the switch.
Okay.
To move the switch 2 inches, they have to reroute the wiring. To reroute the wiring, they have to pull down a section of drywall that the framing crew just put up yesterday. Because the drywall is down, the drywall subcontractor has to come back and patch it. That takes an extra day. Because the drywall patching is delayed by a day, the painting crew, who were scheduled to start on Tuesday, can't start.
And painters are usually booked solid.
Exactly. The painting crew shows up on Tuesday, sees the wall isn't ready, and says, "We have another job across town. We won't be back for 3 weeks."
Oh, no.
Now, because of the 2-inch light switch, the entire interior finishing schedule is 3 weeks late.
Which delays the flooring, which delays the final inspection.
And ultimately, the entire project is delivered 3 weeks late. So what happens? The owner, who asked for the light switch to be moved, is furious that the building is late.
Right.
They trigger the liquidated damages clause and withhold $100,000 from the general contractor's final payment.
And the general contractor turns around and blames the electrician.
Of course, the general contractor sues the electrician for the $100,000. The electrician says, "Wait a minute, the owner told me to move the switch verbally. They knew it would cause a delay."
It's a mess.
The owner says, "I didn't know it would delay the painters by 3 weeks, you should have told me."
Wow.
And because there is no written change order adjusting the price, adjusting the time, and formally documenting the owner's instruction, you end up with implied, unwritten, ad hoc amendments to a multi-million-dollar contract.
Oh, which is a nightmare.
That leads straight to a massive multi-party litigation where everyone points fingers and the lawyers take all the profits.
So the paperwork isn't there to slow things down. It's a circuit breaker to stop the cascade effect.
A strict written mechanism forces the electrician to pause and say, "I can move the switch, but it will delay the painters by 3 weeks. Do you still want to do it?"
It forces a real conversation.
It forces the owner to acknowledge the consequences of their variation before it happens. Skipping the paperwork to save 10 minutes on a light switch ends up costing you 3 weeks of delay and a year in court.
Okay, that transitions us perfectly into the final and honestly most severe area of risk allocation. We've covered time delays, we've covered scope creep and variations.
Yep.
But what happens when something goes catastrophically wrong and someone actually has to pay out of pocket? We are moving into the end game of risk allocation. Liability, indemnities, and remedies.
This is where the heaviest financial burdens are shifted. This is where companies are saved or bankrupted by literally a few sentences.
And to understand how these massive financial liabilities are triggered, we have to go back to a fundamental grammatical distinction. The difference between a covenant and a condition.
Crucial distinction.
The source material uses a brilliant, relatable example to explain this. It's the story of Bob and his stolen TV.
It perfectly illustrates how absolute risk transfer works.
Let's set the stage. Bob buys a new house. He goes out and buys a massive, state-of-the-art $10,000 home theater TV.
Nice setup.
Right. But a week later, someone breaks into his house and steals the TV. Bob has comprehensive homeowner's insurance, so he's upset, but he thinks he's financially protected.
As he should.
However, Bob is busy dealing with the police, fixing the broken window, and, just managing his life. And he doesn't read his insurance policy carefully.
Oh.
The policy dictates that the insurance company must receive written notice of any theft no later than 10 days after the incident occurs. Bob finally gets around to filing the paperwork and sends the notice on day 12.
He is exactly 2 days late.
2 days late on a 10-year insurance policy. Now, this is where the drafting masterclass really shows its teeth. The entire fate of Bob's $10,000 payout hinges on whether that 10-day notice requirement was drafted as a covenant or as a condition. Break
Yes.
down the stakes here. Let's start with the covenant.
A covenant is simply a contractual promise to do something or not do something. If the insurance policy was drafted as a covenant, the language basically means Bob promised the insurance company, I will tell you within 10 days if something is stolen.
Okay.
By sending the notice on day 12, Bob broke his promise. He breached the contract.
So the insurance company doesn't have to pay.
No, this is the crucial part. Breaching a covenant usually just entitles the non-breaching party to damages caused specifically by that breach.
Just the breach itself.
Right. The insurance company would have to prove how Bob's 2-day delay financially harmed them. Maybe the price of replacing that specific TV model went up by $50 in those 2 days. Or maybe they lost 2 days of investigating the crime scene while the trail was hot.
So he owes them for that delay.
Bob owes them damages for whatever that delay cost them. But the insurance company still has to fulfill their main obligation, which is paying out the claim for the stolen TV.
So under a covenant, Bob might get a slap on the wrist. Maybe his payout is reduced by $50, but he still gets the $10,000 for his TV.
Exactly. But insurance companies employ very sophisticated drafters. They almost never draft notice requirements as covenants.
What do?
They draft them as conditions to the obligation.
And how does that change Bob's reality?
A condition establishes a rigid sequence of events. Event A must happen before Event B is legally triggered.
So sequence matters.
Yes. The policy will actually say, providing written notice within 10 days is a condition precedent to the insurer's obligation to pay any claim.
So Event A is the notice. Event B is the payout.
Precisely. Because Bob failed to satisfy the condition, Event A did not happen within 10 days. The insurance company's obligation to pay, Event B, never even springs into existence.
Oh, wow.
The legal duty to pay was never activated. Bob completely forfeits his right to the money. He gets absolutely nothing.
A $10,000 loss over a 2-day delay.
That is brutal.
It really is. But it's a perfect example of how a single word shifting a requirement from a promise to a condition transfers the entire financial risk of the stolen TV straight back to Bob.
And it is worth noting that judges, under common law, generally hate forfeitures.
Really?
Yeah, they hate seeing people like Bob lose everything over a technicality. If the drafting is even slightly ambiguous, a judge will often bend over backwards to interpret the language as a covenant rather than a condition just to save Bob.
Which is why the drafters have to be so precise.
Yes, exactly. Drafters who represent insurance companies or large corporations have to be incredibly explicit. They will write aggressive, undeniable language like, strict compliance with this 10-day notice period is an express condition precedent to recovery, and failure to comply will result in absolute and complete forfeiture of all claims.
No room for interpretation.
None. They have to draft it so tightly that they remove all discretion from the judge.
Wow. Okay, moving deeper into financial risk, we have to talk about indemnity clauses. I feel like indemnify is one of those legal words everyone has seen. It's buried in every software user agreement, every vendor contract, but very few non-lawyers actually understand how it works mechanically.
It's very misunderstood.
Can you define what an indemnity is in the context of commercial risk allocation?
Stripped of the jargon, an indemnity is an agreement where Party A promises to step in and pay for the losses or damages that Party B is financially responsible for, usually regarding claims made by a third party.
Okay, so it's a shield.
It is the ultimate heavy-duty risk-shifting mechanism. If a third party sues you because of something I did or a product I supplied, I promise to step into your shoes, take the financial hit, and make you completely whole.
The sources contrast an unlimited liability indemnity with a negotiated structure. In practice, how dangerous is an unlimited indemnity?
An unlimited indemnity is essentially signing a blank check and handing it to your counterparty.
That sounds terrifying.
It should be. If you agree to an unlimited indemnity, you are agreeing to cover all losses, all damages, and all liabilities forever, regardless of how unforeseeable they are.
Give me an example of how bad that can get.
If you supply a single faulty microchip to a car manufacturer under an unlimited indemnity, and that chip causes a recall of 10,000 cars, you are on the hook for tens of millions of dollars. It can instantly bankrupt a company.
Just from one chip.
Exactly. In sophisticated commercial contracts, indemnities are never blank checks. They are heavily negotiated structures protected by guardrails.
Let's break down those guardrails. How do deal lawyers box in this massive liability?
The Masterclass lists 4 primary negotiated components. The first is caps on damages.
A ceiling on the money.
Right. The indemnifying party will insist on a ceiling. They might say, I will indemnify you, but my total aggregate liability under this entire contract is strictly capped at 100% of the fees you paid me.
Or like a specific dollar amount.
Exactly, like capped at $1 million. You quantify your absolute worst-case scenario.
So even if the recall costs $10 million, you only pay $1 million.
Right, your risk is boxed in. The second guardrail is exclusions. The most critical exclusion is usually a waiver of consequential damages.
Oh, what does that mean?
An indemnity might cover direct damages, like the cost of replacing the faulty microchip. But you explicitly exclude consequential damages, which are the ripple effects.
Like what?
You will not pay for the car manufacturer's lost future profits or the damage to their brand reputation, because those numbers are impossible to calculate and can be astronomically high.
You only pay for the direct breakage, not the butterfly effect.
Exactly. What is the third guardrail? Exceptions to the indemnity. You carve out scenarios where you refuse to pay entirely.
Okay, for example.
For example, I will indemnify you for claims arising from my work, except to the extent that the claim was caused by your own gross negligence or willful misconduct.
Ah, so if they caused it, they pay for it.
If the car manufacturer knew the chip was faulty and installed it anyway, they can't force you to indemnify them.
Makes total sense. And the fourth guardrail is alignment with insurance policies. How does that work?
You might draft the indemnity, so it only acts as a backstop. It only kicks in after the injured party has submitted a claim to their own commercial liability insurance and exhausted their coverage.
So the insurance pays first.
Right. You only indemnify them for their out-of-pocket deductibles or amounts above their policy limits.
It's all about building a walled garden around the risk. But, there was one detail in the text about indemnities that I thought was a massive aha moment.
Which part?
It's about a single phrase that gets added to these clauses. Often, a contract won't just say, Party A shall indemnify Party B. It will say, Party A shall indemnify and defend Party B.
Yes, and defend.
What is the actual financial power of adding those two words, and defend?
Those two words are arguably the most valuable words in the entire contract, and it all stems from a legal concept called the American rule.
Okay, remind me what that is.
Under common law in the United States, every party pays their own litigation expenses, regardless of who wins or loses the lawsuit.
Right, which is totally different from the English rule used in the UK, where the loser generally has to pay the winner's legal fees.
Exactly. The American rule changes the calculus of litigation completely. Let's say you have an indemnity clause that simply says, Party A shall indemnify Party B. A third party sues you, Party B, for $1 million over the product I supplied. Because I only promised to indemnify you, I am only on the hook for the final judgment. While the lawsuit drags on for 3 years, you have to hire your own law firm, pay their exorbitant hourly rates, and fund the entire defense out of your own pocket.
And legal fees add up fast.
Very fast. Even if you win the case, and the judgment is zero, meaning I don't have to indemnify you for anything, you might still be out $500,000 in legal fees that you can never recover.
Wow. So an indemnity without the duty to defend is basically useless if the legal fees bankrupt you before the trial even ends.
It leaves a massive hole in your risk allocation. By adding the words "and defend," you force Party A to not only pay the final judgment, but to actively step in and pay for the lawyers to fight the case from day one.
You are shifting the massive upfront financial risk of the legal process itself.
Yes.
But the expert analysis in the Masterclass points out a massive catch here, a control issue.
The golden rule.
Right. If Party A is paying for your defense, who gets to control the legal strategy?
That is the secondary battleground in negotiating these clauses. It is the golden rule. Whoever has the gold makes the rules. If I am indemnifying you and paying the law firm's bills, I want to control the defense.
Because it's your money.
Exactly. I want to pick a law firm I trust, and more importantly, I want to decide whether to fight the case in court or settle it quietly, because it is my money on the line.
But what if our interests don't align?
That happens a lot.
What if you, Party A, want to just write a settlement check to make the lawsuit go away quickly because it's cheaper than a long trial, but the lawsuit is publicly accusing me, Party B, of fraud or gross incompetence?
Right, it's a reputational hit.
I don't want to settle. I want to go to trial and clear my company's good name.
That is the exact tension that deal lawyers have to anticipate and draft for. Sophisticated contracts don't just say and defend. They spell out the precise rules of engagement for how the defense will be managed.
Like a prenuptial agreement for a lawsuit.
basically. They might grant Party A the right to control the defense, but grant Party B the right to hire their own separate counsel to participate at Party B's own expense.
Okay, that makes sense.
Or, crucially, the contract might state that Party A cannot agree to any settlement that admits fault or liability on the part of Party B without Party B's explicit written consent.
You really have to dictate the mechanics of the divorce before you even get married.
You do.
Before we wrap up, there is one final piece of the financial risk puzzle mentioned in the sources: exclusive versus cumulative remedies and liquidated damages. Let's build those out briefly. Why does it matter if a remedy is exclusive?
When you write these elaborate indemnities or specific warranties into a contract, you have to explicitly state how they interact with the rest of the legal universe. An exclusive remedy clause means this indemnity we just negotiated is the only way you can recover money from me.
It sets a hard boundary.
Right. You waive your right to sue me under common law for torts, negligence, or general breaches contract. You're building a fenced-in, predictable ecosystem of liability.
So a seller or a contractor always wants an exclusive remedy. They want to limit their exposure to the box they just negotiated.
Yes, absolutely. But a buyer or an employer usually wants cumulative remedies. A cumulative clause says, I get the benefit of this specific indemnity, and I retain all my rights to sue you under common law for anything else you might do wrong.
It's a battle over whether the contract replaces the common law or just adds to it.
Exactly.
And finally, liquidated damages. We mentioned this during the delay clause discussion. What is the mechanism here?
Liquidated damages are a transaction-specific remedy designed to solve an evidentiary problem. Let's use the theater production example from the text.
Okay, set the scene.
A contractor is hired to renovate a historic theater. The grand reopening is scheduled for opening night of a massive, highly anticipated play. The contractor finishes 3 weeks late, forcing the theater to cancel the first 3 weeks of performances.
A massive financial hit.
Huge. But if the theater sues for standard breach of contract, how do they prove their exact financial loss?
I mean, they know how many tickets they didn't sell.
Proving the exact amount of lost ticket sales is easy, yes. But how do you prove lost concession sales? How do you quantify the damage to the theater's reputation? How do you calculate the loss of future season ticket holders who are angry about the cancellation?
That's much harder.
It is incredibly difficult, speculative, and requires expensive expert witnesses.
So instead of fighting over the math in court, they agree on the math before construction even starts.
Exactly. The contract states, if the contractor is delayed, they shall pay liquidated damages of $10,000 for every day of delay. It provides absolute certainty. The theater doesn't have to prove their actual damages. They just point to the calendar.
But the sources issue a strong warning about this.
They do. Under common law, private parties are not allowed to impose punitive fines on each other. Only the government can do that. So, courts will strike down a liquidated damages clause if it looks like a penalty designed to terrify the contractor into compliance. The daily amount must be a genuine, reasonable pre-estimate of the actual financial harm the delay will cause.
So if the theater only holds 100 people and tickets are $10.
A $10,000 a day liquidated damages clause will be thrown out by a judge as an unenforceable penalty.
It has to be math, not a threat.
Exactly.
Okay, let's synthesize this incredible journey through the masterclass. We started by challenging the notion that commercial contracts are just administrative hurdles. We've seen how drafting a contract is actually a highly strategic architectural process of risk allocation.
It is a delicate balancing act of power, probability, and liability.
We learned how deal lawyers translate messy business realities into precise legal standards, using tools like materiality qualifiers to filter out noise. We looked at how subjective, fuzzy words like promptly can completely destroy a delay clause.
Setting the alarm clock for morning-ish.
Right, and how replacing them with objective standards like no later than 3 business days acts like a precise alarm clock that prevents litigation. We explored the absolute necessity of managing scope creep with formal change orders and the tiny grammatical difference between provided that and if that dictates who holds the power.
And we saw the cascade effect of what happens when you ignore those formal mechanisms.
And finally, we dove into the high stakes of financial risk. We learned how a single word can turn a broken promise into an absolute forfeiture, like poor Bob losing his $10,000 TV over a 2-day delay, and how adding "and defend" to an indemnity clause can shift millions of dollars in legal fees. Throughout this entire discussion, the power of specific verbs, adjectives, and conjunctions was undeniable. Words are the actual currency of risk.
Ambiguity is the enemy of the deal lawyer, and that actually brings us to a final provocative thought I want to leave the listener with, based on a fascinating section of the source material discussing the words will versus shall.
Oh, I love this distinction. It really changes how you read everyday documents.
Think about the contracts, the user agreements, or even the informal business emails you read in your everyday life. When someone says they shall do something versus they will do something, in standard conversational English, we treat them as absolute synonyms. We use them completely interchangeably. I will go to the store, or I shall go to the store.
It means the exact same thing to a normal person.
But in the hyper-precise machinery of private law, they are entirely different tools. According to the drafting rules we've studied, the word shall is exclusively used to create a binding legal duty. It is a covenant. If a contract says the buyer shall pay the purchase price, it is imposing an obligation. If they don't do it, they are in breach of contract and can be sued.
It is promise.
But the word will is used merely to state a future fact, often completely outside the control of the party making the statement. It is the statement of expectation. The sun will rise tomorrow. The shipment will arrive on Tuesday. If the shipment doesn't arrive on Tuesday because of the storm, the party hasn't necessarily breached a duty. A future fact just failed to materialize.
It is a statement of expectation, not a legally binding obligation.
Exactly. So the next time you read a software user agreement, or you sign a lease for an apartment, or you review an employment offer, look very closely at those verbs. Ask yourself, are you reading a legally binding promise that you can actually enforce in court if things go wrong, or are you just reading a casual prophecy about the future?
Are you reading a promise or just a prophecy? You think you are reading an ironclad guarantee, but you might just be reading a weather forecast. We want to thank you for joining us on this deep dive into the hidden, paranoid, and utterly fascinating machinery of contracts.
It has been a real pleasure unpacking the architecture of these deals.
Remember, the next time you are asked to sign on the dotted line, that document isn't just a formality. It is a highly customized insurance policy built word by word, comma by comma. Keep questioning the fine print, keep looking for the mechanism behind the legalese, and most importantly, never, ever accept the word promptly. We'll see you next time.